So when exactly does a legal pretense become a genuine constitutional danger? Welcome back, aspirants, to this rapid-fire special explainer from Rungta IAS Academy. Today, we're targeting a really high-scoring, but honestly, kind of tricky area for your General Studies Paper 2 Polity syllabus, the 10th schedule and the mechanics of political mergers. I'm joined by my esteemed colleague, and together we're going to dissect how a legal concept that was actually meant to adapt to changing societies has recently sparked some massive constitutional debates. Let's dive right in. To really grasp why this topic is just burning up the current affairs right now, we just need to look at the recent events from this past April. The Rajya Sabha chairman accepted the merger of 7 Aam Aadmi Party MPs with the Bharatiya Janata Party. Now look, as serious UPSC aspirants, you shouldn't just be glancing at the political headlines, right? You need to look at the actual constitutional machinery at work here. Is a resolution by the legislators enough to constitute a full merger? Well, to answer that, we really need to understand the theoretical underpinning of what the law calls a legal fiction. Over to you, Professor.
Right, thank you. Now, for your mains essays, you absolutely must build a strong theoretical foundation before you even start discussing the case laws. Sir Henry Maine, back in his 1861 work Ancient Law, called legal fiction an agency by which law adapts to changing societies. It's basically the law pretending something is a fact, kind of like an adopted child being legally treated as a natural child. But consider this brilliant warning issued by the jurist Lon Fuller in his 1967 monograph. He warns us that a fiction is a tool fashioned for a defined end. If we forget that it's just a pretense and we start treating it as absolute fact, well, it loses its utility and becomes incredibly dangerous.
So how does all this apply in our Indian constitutional context? Well, the benchmark was set way back in the 1955 Bengal Immunity Company case by a 7-judge Constitution bench. Acting Chief Justice S.R. Das clearly defined a legal fiction as a tool created for a definite purpose, limited strictly to that purpose, and which must not be extended beyond its legitimate field. Aspirants, please note this down, it's absolutely crucial. This exact discipline was remarkably reaffirmed by the Supreme Court just recently on March 10th in the Register Kane Cooperative Societies case. The principle is rock solid here. A deeming clause simply cannot override its original boundaries. Spot on. And, this brings us to the absolute crux of aspirant confusion regarding paragraph 4.2 of the 10th schedule, the Anti-Defection law. The text states that a merger shall be deemed to have taken place if, and only if, 2/3 of the legislature party agree.
Exactly. But here is where students make a fundamental mistake, literally all the time. The substantive condition is that the original political party must merge. The 2/3 legislative assent, that is merely the verifying count. It just tells the adjudicator how to verify a merger that has already happened at the parent party level. It absolutely does not mean the legislator's assent is the merger itself.
Let's map out the evolution of this judicial stance to make it crystal clear for your exams. We start with the 1955 Bengal Immunity precedent we literally just discussed. Then, crucially, the 2007 Constitution bench in Rajendra Singh Rana versus Swami Prasad Maurya. The Supreme Court explicitly stated that allowing the legislative party threshold to satisfy the substantive event in the original party would basically render one limb of the clause completely redundant. This is a principle that was subsequently echoed by the high courts.
Yes, exactly. And we saw this applied so clearly by the Punjab and Haryana High Court in the 2011 Kuldeep Bishnoi case. The ruling was unambiguous, guys. Legislators alone cannot affect a merger. The original political party itself must take the substantive decision.
However, and this is where it gets interesting, recent practice has kind of allowed distortions of this established law. For instance, the Bombay High Court's Goa bench has twice upheld merger orders based solely on a 2/3 resolution of legislators, first in 2022 and again very recently in January 2025. And similarly, the Rajya Sabha chairman's administrative decision in April accepting the AAP MP's merger with the BJP, it relied on this exact same reading. By completely bypassing the original party's authorization, these recent decisions directly contradict the Bengal Immunity and Rajendra Singh Rana precedents we just analyzed together. Which finally brings us to our conclusion. And honestly, a critical analysis bouncer question for your upcoming personality tests. When does a legal fiction become a dangerous substantive grant of power? Well, the doctrinal reason is this. When you read a deeming clause as constitutive rather than just verifying, it ceases to be a fiction. It actually becomes a substantive grant of power to a mere faction of legislators, allowing them to declare a merger that the parent political party never even authorized. This is precisely the danger Lon Fuller named, and exactly what Acting Chief Justice Das sought to prevent. So aspirants, as you analyze the 10th schedule, ask yourselves, are we allowing the verifying count to swallow the substantive law? Ponder on that. Thank you for joining this special explainer, and keep studying smart.